If you're watching this video, chances are you're facing one of the most important questions any parent or family member can ask. What happens to my special needs child when I'm no longer here to care for them? Or maybe you're asking, how can I make sure they're taken care of without losing the government benefits they desperately need? Hi, I'm Chuck Roulet, and I've been helping families answer these exact questions for nearly 30 years as an estate and elder law planning attorney. And I've seen how the right trust can transform a family's future. And I've also seen the heartbreak when families don't plan properly. And today I'm going to walk you through what you need to know about special needs trusts and supplemental needs trusts. And by the end of this video, you'll understand what trust is right for your situation, how to protect government benefits, and what steps to take next. Now, before we begin, if you haven't already, make sure you click the like and subscribe button so you'll be notified when I post new videos like this one. And make sure to share it with anyone that may find the information helpful. If you have a question, post it in the comments and I may answer it in an upcoming video. And if you stay until the end, I'll share some resources where you can discover more. All right, let's start with the basics. What exactly is a special needs trust? Well, a special needs trust, sometimes called a supplemental needs trust, is a legal tool designed to hold money and assets for someone with disabilities without disqualifying them from important government benefits like Medicaid and Supplemental Security Income, or SSI. So think of it this way. These government programs have strict income and asset limits. In most states, if you have more than about $2,000 in your name, you can't qualify for SSI or Medicaid. So here's the problem. Let's say your special needs child receives an inheritance of $50,000 or $100,000 or more. If that money goes directly to them, they lose their benefits overnight. They'd have to spend down almost all of that money before they could qualify for benefits again. However, a properly structured special needs trust prevents this from happening. The trust holds the money, and a trustee, that's the person who manages the trust, uses it for your loved one's benefit without affecting their eligibility for government programs. Now, why does this matter so much? Government benefits aren't just about monthly checks. Medicaid often covers essential Medicare, therapy, equipment, and services that private insurance won't touch. We're talking about things like occupational therapy, speech therapy, specialized medical equipment, home health care, and so much more. So losing Medicaid can mean losing access to care that your loved one literally depends on for their health and well-being. SSI provides monthly income to help with basic living expenses. So for many individuals with disabilities, these benefits form the foundation of their financial security. And that's why getting the trust structure right is absolutely critical. Now, here's where things get really important. Not all special needs trusts are created equal. There are two main types, and understanding the difference could save your family tens of thousands or even hundreds of thousands of dollars. So here are the two types. The first one is a first-party special needs trust, also called self-settled trusts. The second one is third-party supplemental needs trusts. Now, the difference might seem technical at first, but trust me, it has a huge practical implication for your family. So let's break them down. A first-party special needs trust is used when the person with a disability already has money or assets in their own name. Now, you might be thinking, well, when would that happen? Well, actually, it comes up more often than you would think. And here are the most common situations. First is personal injury settlements. Your child is injured in an accident, maybe a car accident or a medical malpractice case, and they receive a settlement. We're talking sometimes $200,000, $400,000, even $1 million or more. Second is an inheritance that's received directly. Maybe a well-meaning relative, maybe a grandparent, passes away and leaves money directly to your special needs child in their will or trust. They meant well, but they didn't realize that this could cause a problem. Third is back pay from Social Security. Your loved one is approved for disability benefits and receives a lump sum of back pay for all those months or years they were waiting for approval. Fourth, divorce settlements where assets are awarded to the person with disabilities. And fifth is often life insurance proceeds when your loved one is named as a direct beneficiary. So let me give you a real example that drives this home. Sarah is 32 years old. She has autism and receives SSI and Medicaid. She was a passenger in a car and there was an accident caused by a distracted driver. The insurance company offered to settle for $400,000. Now, if Sarah had accepted that money directly, if it went into her bank account, she would have lost her SSI and Medicaid immediately. Not next month, not next year, immediately. She would have had to spend down nearly all of that $400,000 on her own care before qualifying for benefits again. Now, think about that. $400,000 sounds like a lot, but with medical care, therapy, attendance services, that money could disappear in just a few years. And then she'd be right back where she started, except now she'd be older and might have higher care needs. Instead, her family worked with an attorney, someone experienced in this area, to establish a first-party special needs trust. That settlement money went into that trust. Sarah kept her benefits, and now the trust pays for things that make her life better. A specialized computer that helps her communicate, therapy not covered by Medicaid, recreational activities, even a part-time companion who takes her to events and activities. The trust transformed her quality of life while protecting her access to essential benefits. Now, first-party trusts are authorized by federal law. Specifically, it's Title 42 of the United States Code, Section 1396P, subsection D, Paragraph 4, subparagraph A, often shortened to 1396D4A trusts. Now, I know that's a mouthful, but this is the federal statute that allows first-party special needs trusts to exist and sets the requirements they must meet. And this law was later amended by the 21st Century Cures Act in 2016, which made some important changes I'll tell you about in a moment. So here are the critical requirements for a first-party trust. Now pay close attention to these because if you miss even one, the trust won't work. First, and this is huge, there's an age limit. The person with disabilities must be under age 65 when the trust is established. Now this is a hard and fast rule, there are no exceptions. So if your loved one is 65 or older, you generally cannot use a first-party trust. Now there are pooled trusts that might still work, which I'll cover later. Second, the beneficiary must meet Social Security's definition of disability. They need to have a physical or mental impairment that's expected to last at least 12 months or result in death, and that impairment has to prevent them from doing substantial gainful activity, meaning they can't work and earn above a certain amount. Third, and this is where that 21st Century Cures Act comes in, the trust can be established by the disabled individual themselves, a parent, a grandparent, a legal guardian, or a court. Now, before 2016, the disabled person couldn't establish their own trust. And that change was huge because it gave adults with disability more control over their own financial planning. Now, here's the part that surprises and sometimes upsets families. When the beneficiary of a first-party special needs trust passes away, any money remaining in the trust must first be used to pay back the state for Medicaid benefits the person received during their lifetime. This is called the Medicaid payback provision, and it's not optional. It's written right into federal law. So let me give you another example to show how this works. Michael had cerebral palsy. He received a $500,000 settlement at age 25, which went into a first-party special needs trust. Over his lifetime, about 30 years, he received approximately $800,000 in Medicaid benefits. That was from medical care, therapy, attendance services, all the things he needed. When Michael passed away at age 58, there was $200,000 remaining in his trust. Now, his parents had named his siblings, Michael's brother and sister, as the remainder beneficiaries. They thought that after Michael passed, his siblings would receive that $200,000 split between them. But here's what actually happened. Before any of that money could go to his siblings, the entire $200,000 had to be paid to the state Medicaid agency to partially reimburse them for the benefits that Michael received. His siblings received nothing from the trust. Now, were they upset about this? Actually, they understood it was the trade-off. This arrangement allowed Michael to receive quality care throughout his life while preserving the settlement money for his needs. Without the trust, he would have had to have spent down that $500,000 in just a few years and then would have had nothing. But I want you to understand this payback requirement because it's often difficult for families to accept emotionally. And the rationale is this. The trust used the person's own money, Michael's money from his settlement, to qualify for Medicaid. The government is essentially saying, we'll let you keep your benefits while you're alive, but we get reimbursed when you pass away. Now let's talk about the other type of trust, and this is the one most families want to know about when they're doing estate planning. It's a third-party supplemental needs trust, and it's funded with someone else's money, not the beneficiary's own assets. This is the trust you create as a parent, grandparent, or other family member to plan for your special needs loved one's future. You would use a third-party trust when you want to leave money to your special needs child in your will or trust without disqualifying them from benefits. You want to make lifetime gifts to help your child. You want your life insurance to benefit your child, or grandparents or other relatives want to leave money for your child. So let me share another example. Robert and Maria Martin have 3 children. Their youngest, Elena, has Down syndrome and receives SSI and Medicaid. Robert and Maria have worked hard their whole lives. They built an estate worth about $1.2 million. That includes their home, retirement accounts, and life insurance. They want to treat all 3 children fairly. They love all of their kids equally, but they know if they leave Elena's share directly to her, if they just put her in their will or trust as 1/3 to each child, Elena will lose her government benefits. So instead, they establish a third-party supplemental needs trust in their estate plan. Now here's how it works. When Robert and Maria pass away, Elena's share, about $400,000, goes into the trust. The trustee, and they chose Elena's older brother with a corporate trustee as backup in case he can't serve, manages the money for Elena's lifetime. The trustee uses the money to pay for vacations, entertainment, a better living situation, technology, activities she enjoys, things that make her life more enjoyable. Elena keeps her SSI and Medicaid because the money is in the trust, not in her name. She still gets her monthly check. She still has her health coverage. And here's the key difference. Pay attention to this because this is huge. When Elena eventually passes away, whatever is left in that trust goes to her siblings' children, her nieces and nephews. It does not go back to the government. The family wealth stays in the family. Now that's completely different from a first-party trust. Now, third-party trusts aren't explicitly authorized by a specific federal statute the way first-party trusts are. Instead, they're recognized under general trust law and by guidance from the Social Security Administration. The Social Security Administration has something called the POMS, the Program Operations Manual System. It provides detailed guidance on when trust assets are counted for SSI eligibility. And the key rule is this: a properly drafted third-party trust that gives the beneficiary no control over the assets is not counted as a resource. That means the beneficiary cannot have direct access to the trust assets. They can't demand money. They can't say, hey, trustee, I want $10,000 today. The trustee must have complete discretion over whether and when to make distributions. That's what protects the benefits. And here's the game changer. The things that make third-party trusts so attractive for estate planning: because a third-party trust is funded with someone else's money, not the beneficiary's own assets, there's no requirement to pay back Medicaid when the beneficiary dies. Zero. None. Now, you as the person creating the trust get to decide what happens to any remaining money. So most families choose to have it passed to their other children, grandchildren, or other loved ones. And this is a fundamental difference that makes third-party trusts much more attractive for estate planning purposes. Now, let me put this side by side so you can really see the differences. So first, we want to talk about whose money. Well, with a first-party trust, it's the beneficiary's own assets. A third party, assets from parents, grandparents, or others. When is it used? A first party is when there's a some sort of a settlement, an inheritance received directly, back pay. A third-party trust, estate planning, lifetime gifts, future planning. Age limit. Well, for a first-party special needs trust, you have to be under 65 when created. For a third-party supplemental needs trust, there's no age limit. Who can create it? A first-party trust, the beneficiary, a parent, a grandparent, a guardian, or a court. With a third-party trust, it's anyone except the beneficiary. Medicaid payback. With a first-party trust, yes, it's required upon death. For a third-party trust, there's no payback required. Remaining assets. With a first-party trust, they go to the state after Medicaid payback. With a third party, it goes to whoever you choose. So can you see why this matters so much? Now, there's actually a third type of trust worth knowing about. It's called a pooled trust. Now, pooled trusts are authorized under federal law and offer a unique solution for some families. Here's how they work. A pooled trust is managed by a nonprofit organization. Multiple beneficiaries have individual accounts within the trust, but the organization pools all the assets together for investment purposes. Now, the key advantages are, first, there's no age limit. So remember how I said first-party trusts can't be established after age 65? Pooled trusts can be. So if your loved one is 68, 70, 75, they can still use a pooled trust. Second, there's professional management. The nonprofit handles all the administration and trustee duties. You don't have to worry about finding a trustee or them knowing all the complicated rules. Third, it's often a lower cost option. For smaller amounts of money, maybe $50,000 or $75,000, it might be more cost effective than setting up an individual trust. The trade-off, though, is that, like first-party trusts, pooled trusts may require Medicaid payback. However, the trust document can allow the nonprofit to retain a percentage of remaining funds for the benefit of other trust beneficiaries, which some families actually find appealing, knowing that their loved one's remaining funds will help other adults with disabilities. All right, so now one of the most common questions I get is, if the money is in the trust, what can it actually pay for? What good does it do to my child? That's a great question. Now, the short answer is the trust can pay for virtually anything that supplements but doesn't replace government benefits. Now, here's a list of some things a special needs trust can pay for. Medical and dental care not covered by Medicaid or insurance, things like specialized treatments, alternative therapies. Therapy, rehabilitation, and specialized equipment. Education and tutoring. Personal care attendance beyond what Medicaid covers. Entertainment, hobbies, and recreational activities. This is huge for quality of life. Vacations and travel. Electronic equipment, computers, tablets, phones. Specialized communication devices. A vehicle and vehicle modifications. Furniture and household goods. Clothing beyond basic necessities. Professional services like legal help, accounting, care management, even burial and funeral expenses. The list goes on. Also, this is something you really need to know. You shouldn't give cash directly to the beneficiary. That can disqualify benefits. The trustee should pay vendors and service providers directly. A knowledgeable trustee and experienced attorney can help navigate these rules to maximize what the trust can do for your loved one. Now, in my 3 decades of practice, I've seen families make the same mistakes over and over. So let me share the 5 biggest ones so you can avoid them. Mistake number 1 is leaving money directly to the special needs person. This is the most common mistake. People don't create a trust and they leave money directly to their special needs child in their will, or they name them as a beneficiary on life insurance. Without a trust, that money goes directly to your loved one. They then lose benefits immediately and have to spend down the money before requalifying. The solution? Create a third-party supplemental needs trust in your estate plan and then name the trust, not your child, as the beneficiary of your will, life insurance, and retirement accounts. Mistake number 2, trying to do it yourself. I see this a lot. People find some generic trust form online or try to draft something themselves. Generic forms don't account for the complex federal and state rules governing special needs trusts. One wrong provision, just one sentence that's not quite right, can destroy the trust protective benefits. So the solution is to work with an attorney who regularly handles special needs planning and understands both Medicaid and SSI rules. This is a specialized area of the law. You want someone who does this regularly, not someone who does one every couple of years. Mistake number 3, forgetting to update beneficiary designations. And this one breaks my heart because it happens all the time. You do everything right. You create a perfect trust with an experienced attorney, but then you forget to change the beneficiary designation on your life insurance, on your 401k or your IRA. And when you die, that money goes directly to your special needs child because that's what the beneficiary form says, not to the trust. And all the planning was for nothing. The solution is, after you establish the trust, review and update all your beneficiary designations. Mistake number 4, not planning for who comes after you. You name yourself as trustee, but you don't name successor trustees. Or you name your other child without asking them if they're willing and able to serve. Well, what happens when you can't serve anymore? Or what if your other child lives across the country and really can't handle these duties? The solution is to have honest conversations with potential successor trustees before you name them. Also, consider naming multiple successors and including a professional trustee, like a bank or a trust company, as a backup option. Mistake number 5, assuming it's too expensive. Many families put off planning because they assume they can't afford it. Well, it must cost $10,000, $20,000. Meanwhile, without a trust, their loved one could lose benefits worth tens of thousands of dollars per year. So the cost of not planning is almost always higher than the cost of proper planning. Have a consultation with an experienced attorney to understand the actual cost. For most families, proper planning is far less expensive than the benefits that could be lost without it. Now, let me address the question I know is really on your mind, the one that keeps you up at night. What happens to your special need child when you're gone? I've sat across from countless parents in my office over the years, and I can see it in their eyes. The worry, the fear. Who's going to advocate for them? Who's going to make sure they're treated well? Who's going to love them like I do? I get it, I really do. And here's what I want you to know. A properly structured special needs trust is part of the answer, but it's not the complete answer. Your complete plan should also address guardianship. Who will make personal and medical decisions for your child if they can't make those decisions themselves? You should consider a letter of intent. This is a detailed document explaining your child's needs, preferences, routines, medical history, what makes them happy, what upsets them, how they like things done. This is invaluable for whoever is caring for them. Housing, where will your child live? With siblings? In a group home? Independently with support? You need to think through this and discuss it with your family. Care coordination. Who will manage the team of professionals and caregivers your child needs? Who's going to make sure doctor's appointments happen? Medications are filled? Therapy continues? The trust ensures there's money to pay for your child's needs. The rest of your plan ensures someone you trust is there to make sure those needs are actually met. So what should you do next? Well, if you've watched this far, you clearly care deeply about protecting your loved one's future. That puts you ahead of many families who put off planning until a crisis forces their hand. So here are your next steps. Step 1 is assess your situation. Ask yourself, does my loved one currently have assets in their own name? Well, then you may need a first-party trust. Am I planning for the future and want to leave money to them? Well, then you need a third-party trust. Is my loved one over 65? Well, you may need to look at pooled trusts. Do I have an existing estate plan that needs updating? Step 2, gather information before meeting with an attorney. You want to collect documentation of your loved one's disability, information about current government benefits they receive, details about assets that need to be protected, and names of potential trustees and guardians. Step 3, consult with an experienced attorney, and I can't stress this enough. Special needs planning is specialized. You want an attorney who regularly handles special needs trusts, not someone who does one every few years, who understands both federal and state Medicaid rules and stays current on changes in the law, and then takes the time to understand your family's unique situation. Step 4, communicate with your family. Once you have a plan, make sure key family members understand why the trust is structured the way it is, who the trustees and guardians are, where important documents are located, and how to access professional help if needed. So if you would like to discover more, to schedule a consultation to discuss your own planning, visit us at rouletlaw.com. We have offices in Minnesota and Florida, and we've spent nearly 30 years helping families just like yours navigate these exact situations. If you would like to discover more, join us in my upcoming exclusive Masterclass, where I will reveal strategies I use with my private clients to help them avoid probate, save on taxes, protect the money they leave for their kids in the event they get divorced, and much more. You can click the link in the description below to sign up. Let me leave you with this. I understand the weight you carry as a parent or family member of someone with special needs, the constant worry about the future, the fear of making a mistake that could cost your loved one their security. You can't control everything, but you can control whether you have a solid plan in place. A properly structured trust, whether first party or third party, isn't just a legal document. It's your promise to your loved one that they'll be taken care of. It's your gift of security, dignity, and quality of life. The families I work with tell me that once their plan is in place, they sleep better at night. They have peace of mind knowing that even if something happens to them, Their child will have the financial resources they need without losing the government benefits they depend on. That peace of mind, it's priceless. Don't wait until a crisis forces your hand. Take action now to protect the person you love. Thanks for watching. I hope you found this helpful. And if you did, please hit the subscribe buttons so you'll be notified when I post new videos like this one. And then be sure to share it with anyone who might benefit from this information. And remember, click the link in the description to join my upcoming masterclass or visit us at rouletelaw.com to schedule a consultation. I look forward to seeing you in an upcoming video and the masterclass. Be well.